First of all, a big thank you to Coca-Cola for sponsoring the Panhandle Theater back here. And so we're going to go get forward. My name is John Gessner. This is Denney, Ramirez, and David Denney. And we're going to be inviting three mixologists of local fame that are here in San Antonio to be mixing some drinks for us, and I'll be introducing them as they come in. So when we were trying to figure out how to do this panel, there were a couple of things we were looking at of what shared experiences or what happened during COVID. And one thing that didn't change while all of us were shut down or in our houses or trying to work, the law didn't stop. The courts kept going, the legislatures kept going, we got new developments in. So today we're going to talk about new developments in the hospitality areas of alcohol. We're going to talk about new developments in employment and immigration law, and then new developments in real estate law. So as we get started, the other thing that we thought about as was a constant is apparently in the United States during COVID, the sale of alcohol almost doubled. And the use of alcohol seemed to go up quite a bit. So we thought, okay, what's the best way to make law more palatable? So we're going to be serving drinks as we go forward, and we're going to be having 3 cocktail exhibitions of custom-made cocktails. And while they're making the cocktails, we're going to have TRA team members who are going to be circulating among you with drinks. So hopefully that you'll enjoy the drinks, but I will tell you one thing: you must dispose of the glasses at your seats. You can't throw them at the speakers, no matter what we say, and that includes any garnishes on them. So without further ado, we'll get started. My name's John Gessner. I am the national co-chair for the hospitality section for Fox Rothschild, and I am the past chairman of the Texas Restaurant Association. I've been working as a lawyer in Texas for 37 years, and for the last probably 35 years, I've been doing hospitality representation and alcohol laws particularly. So we're going to talk about it right now. It's my absolute pleasure to introduce our first mixologist, Rachel Rainwater. Rachel has been in the hospitality and customer service area for 13 years. She's been a server all the way up to a GM. In 2019, she competed in the Espolon cocktail fights and won the Southwest title. Has competed in Guadalajara and competed at the Portland Cocktail Week. So without further ado, Rachel, why don't you tell us what you made for us today?
Hi everyone, my name's Rachel. John covered most of it, but I have been in hospitality for a very long time, done a little bit of everything. But the whole point is making your customer happy, and that's what you try to do. So I thought I'd make a really nice, fun summer cocktail that's not crazy boozy, but also packs a little punch. It's not going to be your, generic, boring summer cocktail, just something a little more interesting. So we've got Waterloo Antique Gin. That's out of Dripping Springs, so pretty local. And everybody's favorite Aperol. Then I have a pink peppercorn syrup. This is going to be a very rich syrup, and anyone could make this at home as well. It's just a simple syrup, but the pink peppercorns were allowed to steep and the simple syrup to reduce. Makes it really rich, so it can stand up to this whiskey barrel-aged gin, which is delicious.
Gladys will be next.
And there will be a little bit of tricolor peppercorn on the top of y'all's cocktails. Get a little bit of that pepperiness on the nose as well. What's fun about the peppercorn is it does kind of make the cocktail a little bit savory, even though it is light and refreshing. Enjoy. Cheers. Oh, it's a Pinky Lee. It's like Rizzo, it's got a little bit of kick to it.
Thank you.
My pleasure.
So thank you for being here, and the way to talk about responsible alcohol service is to get everyone inebriated as soon as possible. So cheers. Oh, that is very good. That's very good. Thank you, Rachel. I
My
appreciate it
pleasure.
very much. So let's talk for a minute about responsible alcohol service. The legislature in Texas just finished its biannual 5-month meeting, where they start the first 2 months and do almost nothing, and then spend the last 3 months frantically trying to do everything. And they've developed quite a few bills. And the Texas Restaurant Association basically was an advocate for changing some of our alcohol laws this year, and quite a few laws got changed. And I know all of you have heard about alcohol to go, which I'm going to be talking about, but there are some details in alcohol to go that you need to be aware of, because there are, just like anything else having to do with alcohol service, there's a few details that are a little bit hinky that you need to be aware of. And just to let you know, TABC, during the pandemic, I don't want to say they stopped enforcement, but they certainly weren't as active, because their goal was to keep us open as much as possible. I think that grace period is ending, so I would urge you to if you don't understand the details of your service, then maybe it's something you ought to talk to with your service provider, simply because there are some details we need to do. Let's talk about HB 1024, which is the alcohol to go. First of all, this is a bill that's retroactive, basically. It was in effect from the minute the governor signed it, and he signed it on May 12th, so it's currently in law right now. Some of the other bills we'll talk about won't come into play for a couple of months. So it basically allows, it would create what makes permanent what the emergency order was from the governor, which allows the sale of alcoholic beverages to go or for delivery. Now, in order to be able to do that, you must have a mixed beverage or a private club with a food and beverage certificate. And we're going to talk more about the food and beverage certificate. There have been a lot of criteria for what constitutes the sale of food and beverage. If you're a restaurant, typically you're eligible to get one, but you cannot, even if you have a mixed beverage or you have a private club, you cannot be giving alcohol to go or for delivery until you have that food and beverage certificate. The beverages have to be an original sealed container or a tamper-proof container. And basically what they're saying is you can sell, beer in the can, wine in a bottle, or spirits, but spirits can't be above a 0.375 milliliter opening, basically a small. And I will tell you, there's not that many of those out there right now. The manufacturers are coming in more to try to provide more of those. But as far as the sale, so you can't just sell a fifth or some sort of liter or a handle in connection with the sale of alcohol, even though you have the right permits. What they're talking about with tamper-proof containers, it has to have two parts. It has to have a label that clearly labels it to be alcoholic beverages, and it has to have the name of your business wherever you sold it. The TABC rules have come out, and they've already adopted some rules in this one, and they're working on modifying those. But under the TABC current rules, a customer may pick up the alcohol. It can be delivered only with a food order, but there's no ratio. It's not a certain amount of food versus a certain amount of alcohol. If they're getting food, they can get alcohol. The third party acting as an agent for the restaurant may deliver. That means basically somebody you hire, or you can bring in an independent contractor who has a consumer delivery permit, and your independent contractor would be your third party delivery systems. The Uber Eats, the Favors, those types of group. So, but they have to have the consumer delivery permit themselves, but that's their responsibility. Be aware that from liability standpoint for Dram Shop, if you're delivering it with somebody you bring in, you have liability when it's delivered. However, if you're turning it over to a third party service, the liability changes to them. What is eligible to go? Alcohol with a food order prepared by the restaurant. So it can't be just food that you purchase at a grocery store and send along. It's actually got to be prepared by the restaurant. The beer, wine, or distilled spirits, the tamper-proof containers beer and wine can be in sealed or tamper-proof containers, and the mixed drinks can be in a tamper-proof container. What they call tamper-proof is a container that shows if it has been opened, and the recommendation or the suggestion that the TABC giving is you can put a cup in a bag that's sealed with a zip tie or shrink wrap. But it's got to be clearly obvious that it can be opened. So in other words, if you put just a top on on a paper cup that can be popped on and off at will, that does not comply. It's got to have some sort of a seal or what a lot of people are doing is putting tape over the top of it with your restaurant name so that if that tape is pulled off, you can see it's been opened. It's got to be in a wet area. There are places in this state that are still dry, so if it's a dry area, you can't deliver in there. You can only deliver in the county where your restaurant is located, or if you're in a city which goes beyond the county lines, it has to be within 2 miles of the city limits. So it can't be, you can't just, if you're in Bexar County, you can't be delivering, up to Williamson County in Austin. It's got to be continuous county. When you have the pickup or delivery, if someone's picking up the alcohol at your restaurant or you're delivering, there's certain criteria too. The recipient cannot be intoxicated, okay, which they interpret as showing obvious signs of intoxication, which all of us know is related to, over service. They've got to be able to show valid proof of age, showing that usually they're preferring a government identified ID that shows a date of birth on it. They must sign a receipt or have some sort of electronic signature that shows that they actually received the alcohol, and you have to keep the receipt for 1 year and make it available for audit if the TABC requests. So those things, and if you do it electronically, you have to maintain those records in a manner in which they cannot be altered after the case. So because the TABC wants to be able to establish that. It cannot go in the passenger seat. So if you're carrying food out to go, you can't put the alcohol in the passenger seat next to them. It's got to go into the trunk, or if it's an area that doesn't have a trunk, like an SUV, it has to go in the rear area, or you can put it in something like a glove box or something like that if it would fit. But you can't just put it on the seat, and a lot of people are making that mistake. So that's the criteria for alcohol to go. There's not, my understanding is there's not a grace period right now, because since the law is active, they are going to be enforcing it. So the TABC expects you to understand it. The next bill I want to talk about was the SB 911, and it's the third-party delivery bill. And you're saying, why would we want to talk about third-party delivery when we're talking about alcohol? Well, this is where the legislative staff of the Texas Restaurant Association, we got fun. We had a little fun with this. And what we did is we redefined what a restaurant is. And the definition of a restaurant is important because under the food and beverage, the current law, the food and beverage certificate requires certain criteria in order to establish whether you're a restaurant. And it went into such details as number of entrees and that type of thing. But the new definition we put into this statute, into this bill relating to third-party delivery, says you are a restaurant if you operate a permanent food service facility with commercial cooking equipment on the premises, and you prepare and offer to sell multiple entrees for consumption on or off premises. So it's real simple. To be a restaurant in Texas now, you have to have a permanent food kitchen with commercial equipment, and you've got to prepare and offer to sell multiple entrees. So there's a sort of a side effect of this, because if you will recall, last session we changed the food and beverage certificate. Originally, you could only get a food and beverage certificate as long as you had at least 50% of food sold in your location. Now, and then we changed it to 60%. Now, the 60% is out the window if you qualify as a restaurant. So if you qualify as a restaurant, it doesn't make any difference anymore, the amount of sales. And you're going to have issues with that in some of the more restrictive cities that already have that. And I think you have an argument that this preempts those. But be aware that, and I was a little tenuous of this because this is a major change in the law. I got with the general counsel for the TABC yesterday, and he confirmed in his mind the 60% rule is out the window. Now, I guess there are limited circumstances where you could be operating a facility that is not a restaurant, that the 60% would apply. It'd have to be something very weird. But as far as they're concerned, the 60% rule, which has been a problem even when it was 50% for all of us, that's going to be out of the door as long as you meet the definition of a restaurant. And the great thing about this is because it was in a third-party delivery bill, even though it affects the alcohol aspects, it really wasn't something that was gone through. And I don't want to say it was slipped through, but I'm not sure everyone understood the context in which it was done. So it's a major win for us as an industry, and especially if you're operating high volume facilities or facilities such as a wine bar or something like that where you have a disproportionate amount of alcohol. The rules have not been completely issued yet. These are guidelines issued by the TABC. They could come out and modify it, but based upon what we've heard so far, the goal is to implement what the governor's intent was and what the legislature's intent was in putting this through, and that is to free up the sale of alcohol. So the HB 1276 was the bill that was allowed grocery sales. So in other words, you could sell products out of your restaurant without a food manufacturer's license, such as, meat or vegetables or paper goods. You need to be aware it does not apply to alcohol. You cannot sell alcohol by bulk under this statute. And I know there's some people out there that says, okay, it says I can sell anything. It's really not anything. It's not affecting alcohol. The HB 1518, which was something not many people were aware of, it's effective September 1st. It says restaurants and bars within hotels can now sell alcoholic beverages to hotel guests at any time. So at any time, day or night, you can, if you're a guest in a hotel, they can sell you alcohol. It's no longer restricted like it was before relating to the sale of now, I don't think they can maintain their bar facilities, but I think they can probably do room service or some sort of food to go, alcohol to go. The retail stores also under this bill can now sell beer on Sundays at 10 o'clock rather than as before it was noon. HB 1755, restaurants with a mixed beverage, customers can now take unopened bottles of wine if they ordered food. So in other words, if you do order food now at a restaurant with a mixed beverage, you can take a bottle with you that's unopened, and there's not a restriction on amount. So if you have a half-price bottle night at your restaurant, you can be selling food to go, and they can take 1 or 2 bottles with them, and you can sell them at the same time. So that's a change that not many people are aware of. HB 2127, which applies also September 1st, and you have to understand sometimes the process in writing these. It says the 18 largest cities in Texas can designate a public entertainment zone where customers can take open containers of alcohol within the public entertainment zone. So if you have a public entertainment zone in your city, that means that basically it's open containers are good. You just can't take it in the parking lot. So if you're going from place to place, at a facility, like for instance, if you had like a street where it was designated a public entertainment facility, like 6th Street in Austin would be a good example of something that can be done, then you can walk around with alcohol open containers, which is a huge difference, and I don't think a lot of people have recognized that. Now, it says the 18 largest cities, so what that tells me is that whoever was trying to push this bill and whatever lobbyists they were doing probably represented the 18th largest city in the state. So they applied it to all of the rest of them. So SB 195 is, okay, and this is something we call it the dance hall bill. It's soliciting someone to buy drinks for your employees. You can lose your license and you cannot reapply for 3 years. And so we call it the dance hall because in the Old West, one of the things was the dance hall girls would come around and they'd ask you to buy them a drink. Now if they do that, that's illegal, and you can lose your license for some time. HB 1927, we all heard about, that's the open carry of guns. So people starting in September 1st, 21 can openly carry guns. How does that impact you? Well, and this is sort of a weird thing that you need to be aware. Even though we just talked about how the 60% rule was no longer applicable in getting a food and beverage, under this, they're still saying if you have 51% sales of alcohol, you still have to have the red sign and no one can bring guns in. So now the blue sign, which is the sign for under 50%, it's gone as of September 1st. But the red sign still applies. So if you're and I know this is confusing, which is why you have 3 lawyers trying to explain it to you, but if you have more than 50% sale of alcohol, even though you can sell alcohol to go and even though you're classified as a restaurant, there's still, because of under the penal code for the weapons aspect, you still can't, no one can come in with guns on their hip or even concealed. Now the TABC still has to issue rules on this, and I will tell you it is it's confusing area, and they still don't have their hands wrapped around it. So the last thing I want to talk about for my portion of the discussion is the safe harbor rule, because the TABC has tightened the safe harbor rule a little bit in their commentary, and although it embodies the same issues that were there before, they've added a few little wrinkles. So if you comply with the following requirements, and you sell to, if someone in your restaurant sells to an intoxicated person or a minor, the TABC will suspend a claim against your license, and they call it, abate the claim, where they won't actually go against you to try to revoke your license if you meet the following criteria. For one, the server cannot be the owner or officer of the company. So if the company has a liquor license and you're the owner or you're an officer of that company, and I'm talking about a corporate officer, you can't be behind that bar, because you're behind the bar, you're going to lose your protection from the safe harbor. So even though a lot of us like to be, the man and give alcohol to our friends, and get back there and show how good we can mix it, you lose a lot of protection under the law if you're doing it rather than having your bartender do it. The server has to have a current TABC certification, okay? All the servers and their immediate managers have to have a TABC certification within 30 days of being hired. Now, they've now modified that. It's a very simple certification. It doesn't take any long. It begin completely done online. But you have to have a policy in place that says from the day they hire, they have 30 days to get you that TABC certification. And you have to track it, because it has to be a current certification. So if you don't have a tracking system where you're keeping up when your servers expire, they could put you in jeopardy. So be aware of that. And when they're talking about managers, I get asked all the time, okay, does this include every manager? Well, they say immediate managers. Immediate managers are typically controlling the front of the house. If you have a kitchen manager, it probably doesn't apply to them. But if you want to be safe, the two things I always say is, one, get TABC certificates before they start work, and two, keep all of your front of house personnel with TABC certificates. The employer has to have written policies for responsible alcohol service, and the TABC has a form on their website if you want to look at it, but you have to have some sort of thing that says these are our responsible service issues, and you have to, as an employer, you cannot encourage anybody to violate it. So you basically can't say or do anything that says encourages your service to violate. And the final criteria, which is a tightening up a little bit, if you have 3 or more violations in a 12-month period, then then what's going to happen is it's going to avoid this issue. So it's still there, the safe harbor is still there, but there's still some issues. I think at this time we want our next cocktail exhibition to come up here. Can we get, and while she's getting up here, thank you, I will introduce you to Gladys Estrada. Gladys began her career in the hospitality industry over a decade ago. Since then, she has served in every position from hostess to general manager, accountant to bar manager. Her most recent endeavor as a bar manager for an agave-focused terrace bar has led her to come up with the Siesta After Fiesta cocktail, that's the next one we're going to have. So as soon as she gets up here, we will go forward with that. In the meantime, I'd like an opportunity to introduce our next speaker while we're waiting for the cocktail to be set up. And to my left, immediate left, is Denney Ramirez, who's a partner in Monty Ramirez. He is going to be discussing employment issues with you. He's a board-certified labor and employment lawyer. He advises clients mostly as to do labor and employment and immigration. He graduated from UT Law School and has had multiple times, he's been designated a super lawyer in the state of Texas. He's an ex-Navy veteran and was awarded the Certificate of Special U.S. Congressional Recognition for his work with military families. So you'll be hearing from Denney in just a minute. In the meantime, Gladys, we're up for you.
Thank you, John. Hi, how are you? My name is Gladys Estrada. I am a hospitality service industry professional. I've been in this industry for over 10 years, and there are, just like any other jobs, there are things to love and hate about it. For the most part, it has opened a lot of doors and opportunities for me. I want to start off by saying that the hospitality industry is not the same as service industry. Service without hospitality is just a transaction. It's the difference between, hi, how many? And good evening, how are you doing today? You really have to genuinely care about people in order to be in this industry. Hospitality is whenever you go to your mom's house or your favorite tia's house, and she offers you everything that she has in her fridge. This is what I have in my fridge. For this cocktail, my most recent endeavor, bar manager over at Otro and Domingo, it is an agave-forward bar. So I thought I'd make you something with mezcal. Mezcal is one of those liquors that you either love or hate. It's very smoky. The way that it is cooked, it's completely different than tequila. It's cooked underground. So I did add a little bit of tequila to kind of water down, per se, the smokiness of the cocktail. I added some orange juice, fresh squeezed, house-made strawberry syrup, and a hibiscus tea reduction to add a little bit of the bitters, topped off with your favorite, everybody's favorite, Topo Chico. And I garnished this with a little bit of an orange peel for the essence, for the aromas. Unfortunately, I pre-batched the entire cocktail, but I did add fresh squeezed orange juice, lime juice, lemon juice. And like I said, the hibiscus tea reduction, it did take a little while to reduce. So I'll go ahead and add that into my shaker tin. You always want to double strain your cocktail if it has citrus in it, just in case of any pulp. If you're like me, I do not like pulp in my drinks. And when you express the oil of an orange peel, you really just want it for the aromatics. You don't want to line the rim of the glass with it. It kind of gives you the very first impression of the cocktail that you'll taste is bitter, so you don't want to do that. Cheers. Totally didn't top it.
Thank you, Gladys.
Thank you. Salud. Would you like a cocktail?
Love a cocktail.
Can we get a cocktail for Mr. John here?
Now, they should be dropping off first here.
So
They're not paying us for this. We need the cocktails.
we're not getting paid for this? So I did want to end this with a fun fact. Did you know that in the state of Texas, there is no maximum of amount of hours that one should be allowed to work under salary over 45 grand? To me, that's an issue. The entire point of the hospitality industry is to take care of complete strangers. So why wouldn't we take care of one another? Hopefully, I think that should change. And I'm pretty sure that there are so many people in the industry that have the same thoughts and feelings behind this. Yeah.
Thank you, Gladys.
Thank you. Salud. Now, Mr. Denney Ramirez will take the stage.
Thanks, Gladys. Hi, everybody. So my 15 minutes will focus on an employment law issue that I think is the most relevant for any hospitality or restaurant, not only in Texas, but in the nation. And that is, let's see if I can figure this out, sexual assault and harassment in the workplace. In doing research for this presentation, this area, for whatever reason, is really just increasing in relation to the hospitality industry. And I'm not really sure why, but if you do any research, the headlines are everywhere. You know, from 2 to 3 years ago when the Me Too movement started with the Weinsteins and those big officials in the entertainment industry just had sexual harassment allegations addressed against them. But just beyond that, some of these headlines that are on this presentation just show that sexual assault, which is different from the traditional sexual harassment allegations, are peaking and are important to this industry. And so if you were to ask me, why is that happening? And I don't really know why. You know, it could be partly because of the pandemic. It could be partly because the work shortage issue and we're having to recruit maybe younger employees, maybe less qualified employees. But there could be multiple factors in relation to that issue. But with that said, one issue that's really important for every restaurant owner to know is this new law. It's SB 45. And in relation to what this means for you all, I think is pretty important. It's not listed on here, but the law only applied, and talking about sexual harassment laws, only traditionally applied to companies that had at least 15 employees or more. So SB 45, starting September 1, says sexual harassment allegations and complaints can be brought forth to the government or in a lawsuit if you just have one employee. So who does that really affect? I mean, a lot of restaurants have more than 15 employees, but we're now talking, you know, the taco stands, the taco trucks, or the small operators. You have to be cognizant that now you could be sued under this law. And that's dramatic in relation to Texas law, which is employer-friendly. This is definitely an employee-friendly revision. Additionally, and on this screen is a provision that I think is very important and in my opinion is a game changer. So sexual harassment lawsuits have always been filed. We've seen them in the headlines, right? But what's different now is these lawsuits can be filed against supervisors, against managers, and the way I read the law, it hasn't been tested by the courts, but any individual owner who's implicated in the sexual harassment allegations. Why is that a game changer? So before September 1, if an employee of yours had a sexual harassment allegation, they would sue the restaurant, the legal entity, the corporation, right? That's who's on the hook. And then there's protection for those corporations, which are the corporate veil and everything else. We understand that perspective. But this is a game changer because now if an employee files a sexual harassment allegation against your restaurant, the lawsuit can now be filed against allegedly the supervisor or manager or owner who's implicated in those allegations. I can tell you right now, plaintiffs' attorneys that file these types of lawsuits are salivating. And I say it's a game changer because of this. Put yourself in this example. One of your employees files a sexual harassment allegation lawsuit against your company. Okay, you have insurance for that and there's other protections set forth during that process. But now that lawsuit also is asserted against the individual owner or supervisor or manager. So if I'm that manager that's in that lawsuit, my individual assets are on the line at trial if we lose that lawsuit. Not only can that plaintiff go after the assets of that corporation, but now this law opens the door wide open. If I'm your manager and they're alleging I sexually harassed an employee, does that mean they can go after my own personal income? The way I read the law, it's plain and simple, and it does open the door from that perspective. So this is a game changer, and it puts a lot of pressure in relation to what your managers and owners have to know about this law, okay? Another provision about this law that is employee-friendly, in my opinion, is it states that employers, restaurants, must immediately resolve these sexual harassment allegations. Now, immediately was not previously in the law, and it was specifically placed in the law for a reason. And so, once again, this law goes into effect September 1, and courts have not defined or analyzed this issue, have not told employers what immediate means. But I can tell you right now, it's another argument that a plaintiff's attorney who files a sexual harassment case can allege that the restaurant simply did not immediately investigate, did not immediately resolve, or did not immediately terminate the alleged harasser, right? So it's another hurdle that defense attorneys that defend companies and restaurants in this space has to deal with. So I definitely think this is employee friendly. I think we can see that. I definitely think it's a game changer from step 1 to step 10, from negotiating settlement to trial. So just keep this on your radar in relation to those issues. So let's take a step back. I started at the beginning of this presentation to talk about sexual assault, and I want to talk about a case that I handled about a year ago in the restaurant industry, in which I had a 25-year-old manager, male manager, who hired a 19-year-old female. They started dating, boyfriend, girlfriend. We learned that they had sex in the workplace, consensual sex. They broke up months later, and they had sex 1 or 2 times thereafter the breakup. We get a complaint from that female 19-year-old employee that there's sexual assault, that this manager allegedly forced himself on her to have sex with her twice after they broke up. Long story short, he denied it. He said it was consensual, and she's filed this complaint because he's now dating someone else in the workplace. She's saying, clearly we had consensual sex when we were dating, but these last 2 times I was threatened. I was told I'd be fired. He said he was well known in the restaurant industry. My name would be smeared, and I would not have another job as a waitress ever again. So that case ultimately settled, right? But the message here is that we need to have a game plan in relation to this new law, and we need to make sure we have a game plan to ensure that that type of sexual assault, allegations of that will never occur in your restaurant. So I'll leave you with this. Everyone has an employee handbook, right? That's step one. If you don't have that, you need to have something in writing to basically tell employees you can't harass people. That's step one, and you don't even get to first base if you don't have that as a legal defense. So revisit when you go back and make sure you have that. Secondly, the piece of the puzzle that I tell my clients is it has to be plain English, something that makes sense. We have a workforce with highly educated individuals, and we have a workforce with individuals that have 6th grade educations, GEDs, and didn't graduate. And that's okay, they get the job done. But what I'm saying about plain English in relation to your policies means this. It's got to make sense to people, and if they can't read your handbooks, it's really meaningless. And I'll just leave a caveat with that as well. We have a lot of Spanish-speaking employees in the workforce. Are your policies in a language that they can understand? If you have a highly Japanese workforce, is it in a language that they understand? So that's what I mean by plain English in relation to your policies. As far as open door, the piece of the puzzle here that's important to protect you is, if I'm your employee and I want to complain, is there an avenue for me to complain to? Is it a cell phone? Is it a hotline? So your policies can be 100 pages. It could be the best policy ever written. But if there's no means for me to complain to you, it's meaningless, because how can I complain, right? And so think about your policies about how I can complain, and make sure you have a provision in there, whether it's sophisticated, text me at this number, or a 1-800 hotline, I don't care. Make sure that they can complain. We talked about the law that it now requires you to immediately resolve the issue. Make sure that once you have the policy, once it's readable in plain English, and once it has an open door policy, how are you going to investigate that issue, right? You have to immediately resolve it. Make sure that you have a game plan, a protocol, that if I complain, you know what's going to happen. And now that you have to do it immediately, make sure that you're affecting your legal defense in that type of lawsuit if that were to arise. Retaliation, I'll briefly address this. I complain about a coworker who's my manager. Make sure that you know that your managers aren't retaliating against me for making that complaint. My hours aren't getting reduced to force me to quit. I'm not getting transferred to another restaurant. I'm not getting terminated, worst case scenario. So this is one piece of the puzzle if someone complains about sexual harassment. Make sure the alleged harasser who might be in a management position isn't able to retaliate against that employee. You have to ensure that. Last piece that I'll leave everyone here is training. Each piece of this puzzle is so important, and it doesn't work without one piece. But training, you have to train the managers. Now that they are on the hook individually for these types of lawsuits, they have more skin in the game than they ever had. And you have to ensure that with their boots on the ground, training, dealing with schedules, interacting with your employees, back of the kitchen, front of the kitchen, that you train these employees to ensure that you don't allow a culture of sexual harassment to occur in the workplace. Just as you guys, if you onboard me today, you're telling me I have to wear non-slip shoes, that I have to wear a uniform, and you're messaging that from day one, minute one, right? Are you all messaging the non-sexual harassment culture in your workplace in the first 5 minutes? And if you're not, you need to, okay? So think about that in relation to that perspective, and think about training the trainer, training your managers specifically about what their obligations are, and then training your employees on a regular basis. And it doesn't have to be formal. Don't think you have to put a video in and watch something. This can be done in pre-shift meetings, mentioned in 30 to 1 minute segments, continually on a monthly basis. Don't complicate it, just address it, right? So with that said, sexual harassment, sexual assault, the law has changed, and it will change September 1. Don't let it affect your business. Thank you very much. Okay. Thank you, John.
Thank you, Danny. I appreciate it very much. We're going to let Karen Tartt get set up right now. And while she's coming up and setting up for our third cocktail, I'll give you a little background on her. Karen's been in the hospitality business for 13 years. She's been a bartender, brand ambassador, and is currently manager of Below the Maverick here in San Antonio. She's competed the last 2 seasons on Speed Rack. So let's welcome Karen. Hi. Whenever you're ready.
Okay. Cool. Am I entering myself? Am I entering myself?
No, I introduced you. I just gave your bio.
Okay, I did not hear it at all.
Hi.
Okay. So today's cocktail is called Smoke and Mirrors. So that was the one descriptor that I was given, or the one request I was given was, can you please light something on fire, which I was very happy to do, of course, which is always fun. My cocktail today is a little bit special in that I specialize in making migraine-friendly cocktails and cocktails for folks that have a lot of ingredient sensitivities. So today, I have made a stirred cocktail that's pretty boozy. I ended up fat washing some white rum with some black sesame infused sesame oil. And then I made a spiced apple reduction to go with it. The black sesame is bitter enough on its own that I didn't need to add Ango to this. It just needs a little bit of a stir. I wanted it to have like sort of the heaviness that you would think of when you think of the term or the words like smoke and mirrors. And then I also wanted it to have sort of a smoky flair. So I'm going to torch some dried apples that I also soaked in the syrup and that have been rolled in sugar.
That's freaking awesome.
Thank you. All right. Let these guys cool off for a sec. While I give these guys another stir. All right. And then it gets, well, that's why I have an extra. All right, cool. And we have a smoke and mirrors. Enjoy. This one's for you. Cheers.
Karen, thank you very much.
Thank you.
And as we go around and get those cocktails, there will be a test afterwards. You'll be required to make each cocktail at your seat. So just be aware that we are watching. So we get to our final speaker today. It's my great pleasure to introduce David Denney. He's the founder of Denney Law Group based in Dallas. His focus is on the hospitality industry. He has been a member of the Greater Dallas Restaurant Bar Association since 2013. He was the president in the 2020 to 2021 era. He's been a TRA board member since 2018. He created an event called the DFW Restaurateurs Conference, which is going to be in its 7th year now. He's a prolific writer and speaker, an adjunct professor at the International Culinary School at the Art Institute of Dallas. At this time, I'd like to introduce my friend, David Denney.
Thanks, everybody. It's a little loud back there, so I stood up so I could speak from the diaphragm. We're in the theater. So when Karen and I collaborated on this cocktail, I wanted to showcase 2 things. One, everybody pivoted during COVID. I used to tell you guys not to set things on fire because it's dangerous and kitschy, but I said, what the hell, let's set something on fire this time. It's just a convention center, what could happen? The second thing I said was, we're going to be talking about evil landlords, and she said, oh yeah, smoke and mirrors. That's their number one trick in the bag. So how many of you guys in the audience own your own real estate underneath the restaurant? That is fantastic. Well, this side of the room is like heavy with owners. That's awesome. So that's fantastic. This is going to be helpful to you because this is a very vibrant and invigorating community, and we want you to know what we're about to talk about because you were probably tenants at some point. And you have colleagues who are tenants, and you need to be able to warn them because even though you're landowners of your own place, don't tune out. Don't just find yourself at the bottom of the cocktail and not listen because This is relevant to everybody. During COVID, we saw landlords run the spectrum from kind to satanic. And now, post-COVID, post-PPP, we are seeing the true colors of the landlords come to fruition, and they are ready to get paid. And so my firm specifically, worked on literally over 100 modifications to lease language to deal with COVID-related issues. And now we have seen litigation from landlords increase by about 300%. They want to get paid and they don't care. So we did see early in the pandemic, some of the kinder landlords came out at the very forefront to work with their tenants. They were looking at the long game. They didn't want their tenants to go under because they knew there was probably a possibility that there could be a real estate crisis right at the tail end of the hospitality crisis that we were going to be on. And those landlords are reaping the benefits of having supported that restaurant and hospitality community and the retail community. And they will be well loved and well remembered for many years. But I have to tell you, as probably your experience, they're in the sliver of a minority. And the people that we are dealing with that are REITs, multi-billion-dollar companies, multi-nine-figure, hundreds of million-dollar companies that just have properties and asset managers, they don't care. And they are now using this sort of post-COVID era to wipe out under-market leases from their balance sheets. So here's an example, and I've heard so many of these, but this is the one that I keep telling because it's just so crazy. In June of 2020, one of our clients was open and had not missed a rent payment. Everything was going not well, but they weren't closed. And 3 guys in suits came in, sat at a booth, took some pictures, brought out a measuring tape. That was weird. They didn't order any food. After about 3 hours, she convinced one of them to order an iced tea, paid with a credit card. She Googled that person's name, figured out that they were from a very well-known restaurant brand from Nashville, and they were scouting her space at the invitation of the landlord. The landlord said, when confronted, well, we don't think you're going to make it out of COVID. She hadn't missed a rent payment. We don't think you're going to make it. And even if you do, you only have 3 years left on your lease. They can wait. That's the kind of mentality that most independents are dealing with. And people who are not in independents, and even if you're a franchisee of a flag, you are essentially an entrepreneur also, and you're going to have to deal with that too. So if you are part of a large chain and you have a massive corporate infrastructure behind you, you're pretty much writing your own leases anyway. But as an independent, you need to be very careful. And so here are some of the things that we learned during COVID. If you moved your company offices from since the time that you signed your lease, and your notice address is not what it was in the lease, you need to let them know in writing that your notice address changed. Because when they try to loophole you and send you a default letter, they're going to send it. They're going to finally follow the rules for the first time when they're trying to kick you out. And so they're going to go to the lease, they're going to open the document, they're going to look at the notice address, they're going to send a certified letter there whether they know you're there or not. They will then say, well, we gave proper notice according to the lease. Oh, you guys moved, well, you didn't let us know. We sent the mail where it was supposed to go. You just missed your cure period. Bye-bye. If the lease requires that your attorney be copied, and they don't send copies, you need to let your attorney know that you're getting correspondence from the landlord. You need to make sure that notice of non-payment and default letters are addressed immediately and that you use your cure period to fix it. Because if they tell you something orally, that's the thing that we've seen the most. We're going to work on a rent abatement. We're going to work on a rent abatement. Ignore the letter. The letter's just a formality. It's coming from our asset management. We'll work with you. Oh, sorry, we put that in writing. We sent you a letter. You're in default. You're out. But I thought we were talking about the abatement. No. We defaulted you. It happened so much during COVID. So the PPP money was great because it was available to be used for rent. But once that dried up, the landlord said, you got to keep paying. So some of the other things that we want to focus on are all sort of lessons from COVID, and this is something that I've spoken on before, but it's particularly relevant because of the astronomical rise in usage of third-party delivery. If you have a percentage rent clause in your lease where it's always calculated based on a percentage of gross sales, or it could be, you want to make sure that either you're not going to get it out of your current lease, but in your next lease, when we start carving out exemptions from the calculation of gross sales, like taxes and tips, and we don't want you to pay percentage rent on gift cards that are purchased until they're redeemed, you need to also carve out third-party delivery fees, because you're paying a lot of money, up to 30% fees to these third-party delivery companies. And most of the delivery companies don't net out the fee at the point of sale. They send an invoice. If they send an invoice, you're realizing all of that gross sales, but you know you're realizing the gross sales, but it's minus that 30% VIG. So it's never really going to hit your bottom line. But if it's calculated as part of your gross sales and you're reporting those gross sales to the landlord, there is a possibility that you could be paying rent on it. You do not want to be doing that because you don't actually see that money. The other thing is that you need to, if you have not already put pandemic-related language into your lease, and again, we were doing this through 2020 into 2021 and in all new leases. The pandemic language says, if the government shuts us down again, the following things happen. So, for example, one of the things we might say is, we will pay the rent, if we've been closed 7 days by the government, we'll pay the lesser of our normal rent, or X, 10% of sales for the month, whatever it is. We will calculate it, we will figure it out. But it needs to we need to address what happens if there's another variant, there's another pandemic, there's another government shutdown, whatever. I mean, nobody expected that the government would ever shut down an entire sector of the economy, but they did. So now we know to draft around it. And if it's not in your current lease and we get another shutdown, you're going to be fighting the same fight again. So it's time to put that in there. But when you are looking ahead toward future leases, you got to make sure that's in there. And you have to make sure things like notice, cure periods, what we just talked about with deduction for third-party delivery, all that needs to be in future leases. So as you're looking to growth, as you're looking to add units, these are things that are going to become standard, and you need to know to ask for them. The other thing that we have seen is that landlords will not follow the lease the way that they're supposed to until the very end of the period where they're maybe about to exercise their lien on your equipment after they've defaulted you. Then they start giving people the right notice, then they start doing this. So at any point that they are not following the rules, it's time to scream bloody murder, reach out to an attorney if you haven't already. It's really a best practice to make sure that your attorney is copied on all notices that come to you in the lease, and that a notice that doesn't go to your lawyer is not valid, because who knows what happens to certified mail that goes to a restaurant? You'll never see it. First of all, if you have an office in the restaurant, it's where you have a file cabinet with employee files and a printer and an old PC and nothing. And employees don't know what to do with really important green mail, and it might sit for 2 weeks. It might sit through the end of your cure period. If you're on vacation, if you're at the other location and not the one that got the notice, you'll miss it. And so you want a backstop. You want somebody else to be able to see that you are about to be in big trouble. And so we have seen all kinds of smoke and mirrors, just really crazy shenanigans from some of these evil landlords. And it 100% will affect the industry's willingness to do business with some of these people in the future. So they were trying to avoid a real estate crisis early, but they may be creating problems for themselves in the future, because now we know who the good guys are and who the really bad guys are. And I, for one, am going to be warning everyone that I can who to stay away from in certain markets, because we know that they're bad actors. So when we get to the Q&A period, if you guys have stories about certain things you've experienced in this, in this topic specifically, please let us know, because there's a lot of shared misery out there. Like I said, some of these landlords have been good. The vast majority of them have just been unwilling to help and push people along, drug things out, not helped with decisions, waited on decisions about rent abatement, and decided to maybe give you a little help, but then tack it onto the back end, or amortize it, or make you pay it back this year, or things that are not particularly helpful so that they could say that they did when they really didn't. So I look forward to talking with you guys about it as we sort of wrap up the session, move into some Q&A. It has been incredibly eye-opening. And so here's another thing that I know all of you guys have heard. When you sit down to negotiate a lease, the landlords typically tell you, we're going to be partners in this. We're all really excited. Whenever you hear a landlord say, we're going to be partners, it is a lie. Lawyers aren't supposed to, sorry, we're supposed to say it's a misrepresentation. They're lying. They are not your partners. It is my opinion that it is a terrible business move to let a landlord invest in your company. And I also don't like it when they try to characterize it as a partnership, because as soon as the ink on the document is dry, they are no longer your friends. They've got you. If you realize there was something in your letter of intent that didn't make it into the lease and the ink is dry, tough. They got you. If they tell you you're allowed to put an entity on your lease, and they say, well, we'll just get around to it, put your name on it, they've got you. They can't be trusted. And so it's the most important contract that you'll sign. It is the longest and most expensive contract that you'll sign, more expensive and dangerous than a banknote. And it really bears scrutiny. And I know, like, it's all glass half empty, right? But I'm telling you, there are a lot of things where we can look at with glass half full. Not this. Not this. Be very, very careful. Be very suspicious. Do your homework. Do your due diligence. Talk to other tenants. See what their experiences have been like. It's just like picking a spouse. You wouldn't pick a spouse who you'd never met one of their friends ever. So go see what the people in that shopping center's experience has been like. They're going to do their due diligence on you. You should do it on them. And how are we doing on time? We're good? Okay, so as you can see, I tend not to be very frank about my opinions. But in this particular case, they're pretty strong. So I'm happy to talk to you guys afterwards. And I hope you've enjoyed our cocktail, our flaming smoke and mirrors. And I just want to give a recognition to my two colleagues up here. I like these guys so much. It's always fun to present with them. And I think we're ready to move into Q&A, right?
We are. Except we have one thing that's very important to do beforehand. Who made the best cocktail? So everyone who liked cocktail number 1 the best, raise your hand. Okay. How about cocktail number 2? Cocktail number 3?
That's about an even split.
Even split.
I mean, that's the easy thing to say, but it actually looks right.
My only problem with the cocktails is the glasses are really small.
That's right. We got a hand over there. Are you talking about the booze?
So what we're going to do now is basically you have us up here for a limited amount of time. You're not paying any of us fees. We will be giving you not specific legal advice, but general discussions of what you want to do. So at this point, we'll recognize questions from the audience, and Deborah there will bring you a mic if you have a question. Henry.
Yes, Henry from Henry's Homemade Ice Cream, and I have a question for the panel I wanted to ask. I think my landlord's good because I never ever see them, and they never really ever contact me. But my question is, they're a huge company, and I'm just a little guy in a small town trying to make ice cream. So how do I negotiate with them when every time I ask them for something, they say no? Like, for instance, maybe power washing out front? No. Can we put some salt out because there's snow out there? No. And yet I'll get a bill for these because other parts, we have a large Tom Thumb near us that gets anything they want, but the small guys don't get anything in my shopping center. They are the anchor, and every other business in there is mostly a small business, and they get nothing from what I can tell. So how do I combat my landlord?
So two things on that. One, if you don't know when your renewal trigger is, you better know. You need to know when that renewal, not when the end date is, when can you first send a legal renewal on your lease? Because that's when you can start putting the screws to the landlord. If you have renewals options left and they know that you're coming and you want to stay, you can leverage that. But Henry, I would make your property manager's life miserable. And you're too nice. You're too nice. The way that, however you're doing it, is too nice.
And remember too, when
right, well, they do. They change out the property managers all the time.
And the problem is they don't change out just the property manager, they change out the landlords. So if anything that's told to you, landlords, they buy and sell property all the time. If you don't have it in writing and it's signed by both parties, most of the time your lease says it's not valid. And one thing that I've been doing, the same thing as David, I've been doing lease amendments because, if your landlord sends you an email and says, I'm going to abate your rent for 3 months, and so you don't pay rent for 3 months, and that's all you ever do, you are in default until you get a lease amendment signed by both parties.
So Henry, tell them I'm not paying that ice melt that I didn't get. At the end of the year, aggregate all of their failures. See, you're too nice. Look at you shaking your head. I don't want to do that. It's not worth it. It is worth it because then you're going to document it. And when it comes time for them to calculate your renewal at market rate, you can say, wait a minute, I didn't get all this stuff I was supposed to get. And I let you know and you didn't do anything about it.
Questions? Yes, sir.
This is more for Denney regarding the HR issues, sexual harassment, and so forth. I'm assuming that all the changes that you've talked about in this legislative session apply beyond just the restaurant industry, right? I'm an architect who supports the restaurant industry, but anyone with title manager is on the hook.
For any employer in the state of Texas.
Any
for that
employer,
matter,
yeah,
correct.
okay. That's all I wanted to make sure of.
Okay.
So
So you're on
glad
the
I attended.
Be good.
Hi, guys. Really quick question. Full disclosure, I pay David as it is. And he's well worth it. When we were talking percentage rent, I get a lot of pushback from the landlord, even though, and we dealt with it during COVID, and they sucked, but percentage rent, they wanted gross sales. Now, gross sales are not real because net sales are real. So in sending them net sales, I also reduced delivery fees as well as excise taxes, which they pushed back on. And then I showed them the federal statute that excise taxes are not part of your sales any more than sales tax is. But what I found was they wanted the gross sales receipts from the POS, and that's what they calculated percentage rent on. Or in our case, any COVID relief they gave us, which they didn't give us any. So a question is there a way in the lease language to make sure the landlord understands our business and the fact that excise taxes that we pay on alcohol, especially alcohol to go, which is different, but the regular excise taxes on the evil liquor, as well as sales tax, which the state collects, as well as employment taxes, are no longer part of our leases. Because they put, I was able to beat it, but it took a lot of work.
We have 10 exclusions.
My lease does because you did it.
We have
so
10 exclusions from gross sales that we routinely use. That include all taxes, that include tips, that include credit card fees. That's 3% to your bottom line if you exclude that from gross sales. And catering, off-site catering. Sometimes they don't like to give you catering because the food is prepared in-house in their space. But special events like this, Taste of Dallas, Taste of Addison, Taste of whatever, those events we exclude from gross sales, and now third-party delivery fees. And if we get pushed back on it, we'll just tell them we're going to calculate it based on the net, here's an example, and that if they audit you, you may end up in court. But if it's written in there, if we can show them during lease negotiations, when it's literally the only time you have any power during negotiation before there's any ink there, is to say, we do not see this 30% that goes to DoorDash. We don't, it's not our money. We're not gonna pay rent on it. And if they say pound sand, then you can say, okay, I guess I'll lease the space, or I'm gonna go next door, go across the street.
Right. Jeffrey, do you have a question?
Yeah, thank you. No, I just like holding the microphone in case I get a chance to talk. So first of all, thank you guys for being here. It was an awesome panel. So I have a question. So I'm a commercial real estate broker in the restaurant industry space, and I'm seeing more and more landlords today taking that what was $1 million insurance to it's creeping. Are y'all seeing that, and can you happen to share why you think that's happening?
They're paranoid. I don't think they're getting sued anymore. They don't want you to go bankrupt if something bad happens. So our pushback on that for an independent is a $5 million base insurance policy is something for a massive 7,000 square foot mega restaurant. So it's almost like a sliding scale based on square footage. It's not necessarily based on sales. So what we try to do is convince them that a couple of $1 million of insurance is adequate, but that we will put an umbrella on that because umbrellas are much less expensive. An umbrella insurance policy is far less. So, and you're right, Jeffrey, that has been happening. And it's now just written in the standard form at higher numbers than it used to be. And if you don't see it, then you've signed a lease that says you have to have that insurance or you're in default. So you want to negotiate that down, but you can't just cross it out and then send it back to them. You're automatically gainsaying their form, and then you have to put some context with it. So if you're an 1,800 square foot, 40-seat restaurant, whatever, not even 30 seats, and they want their form, their 45-page lease form says $5 million of insurance, negotiate it down. And get your broker, make your broker earn his bread and have him do it in the letter of intent. It's a lot easier to negotiate it in the lease if it's already in the LOI.
And also, I think it's a good idea to have your insurance agent look at the insurance provisions before you sign the lease, because a lot of these leases are written, especially with the larger companies, they're written in other states, they're written with different amounts. Insuring property in California is way more expensive than insuring property in Texas, but if your landlord is using a form that's based out of California, the numbers are going to be crazy. Yeah. So be aware, because sometimes these leases haven't been written in a while. There are some insurance products come and go. There's some insurance that they used to require that doesn't even exist anymore, and you don't want to be put in a position where you're in default because you cannot comply because the policy doesn't exist, or yes, you can get it, but it'll cost you 5 times what you're paying for regular P&C coverage. Questions? Yes, ma'am.
Good evening. Thank you, guys.
Thank you.
My name is Nina Rangel. I'm the food and nightlife editor for a local biweekly alternative news magazine. I cover a lot of sexual harassment and assault.
Could you talk up just a little bit?
Oh, I cover a lot. Wow, that's really loud. Of sexual harassment and assault stories here locally and throughout the state of Texas and how they affect San Antonio. And I have a question for Denney about what does immediate mean in the eyes of the law?
Can you just say you don't know?
Yeah, so that's a good question. I think immediate means immediate. So the legal standard now set by the U.S. Supreme Court is prompt remedial action. Prompt remedial action legally has been vetted to mean what it sounds like. So if I complain today and an employer investigates fairly soon, courts are going to say that's fine. So the definition of immediate, I think, puts at least some context that it needs to be more than prompt, but immediate sounds fairly quickly. If I had to guess, I would say, look, if a complaint comes in today, Sunday evening, an employer should be at least doing or taking some level of action within 24 hours. I mean, restaurants are open 7 days a week. We're not like an office building. So I think the next day within 24 business hours is a safe rule to follow. Obviously there's caveats, storms, hurricanes, and whatever could happen. But I think 24 to 48 hours is a very good rule to follow.
Shoot for 24, that's good. Do we have other questions?
Hi, my name is Jonathan Tebow. We own and operate Mexico restaurants. I just want to give a quick shout out to Henry's Ice Cream. Is the best ice cream in this entire world. It'll change your life. So you need to order from him. We've been ordering from him for like 30 years, and it's incredible. Cinnamon ice cream for the sopapillas. Okay, on to my question, because I just spent like $500 of your hourly rate asking that one question. So my question was, is there any sort of size requirement on the cups, i.e. we're to-go cups for alcohol sales? Is there a max size? Like, can I put it in a soup container as long as it's sealed? Or
right now, there's not, and there's a lot of people who have been selling pitchers of margaritas to go. That is something that I know they're looking at. The intention was not to deliver gallons of margaritas, but I do know during the pandemic, people were buying and ordering gallons of margaritas. I expect we'll see some sort of rulemaking from the TABC on there, but right now, it's, just back it up and fill up the back of your pickup.
Kiddie pool.
Hey, John, so during the pandemic, how much of a financial impact did alcohol sales impact Texas? And then also, did it save a lot of restaurants because that was now an option for them?
I think it's clearly saved a lot of restaurants, and there's a lot of restaurants that I know that didn't have alcohol before the pandemic that brought it in because it was a way to make the money. As far as trying to calculate how the effects were, it's hard to tell at this point. There are places, the top. If you look at the Secretary of State's records, they'll show the top payers of taxes relating to comptroller. Relating to payments of tax relating to alcohol. And the largest ones that are on those lists are always the gentlemen's clubs, and those were pretty much closed. So I would say pretty much the top 10 alcohol producers in the state probably fell quite a bit. As far as, I think it benefited a lot of restaurants that have drinks that go with the food. For instance, margaritas took a big jump. A lot of restaurants started doing margaritas because those are easy to package. They go well, and it's usually somebody has a proprietary recipe for those. It didn't help a lot of people that were buying Jack and Coke. So.
Use your words.
Thank you, David. One last question is that there's been a little bit of confusion in the third-party delivery services, and we're finding that the third-party delivery services do not all have the ability to transport sealed alcohol to go. Is there any regulation on that, or is it a product of the company themselves? I.e., Uber Eats doesn't do it, DoorDash only does it for specific drivers, and therefore someone that can put in an order sometimes has to wait an hour and a half to 2 hours to receive the order because they ordered 2 margaritas to go.
So as a restaurant operator, one of the things you have to do is if you're going to work with a third-party delivery, you need to identify that they've already received the permit, the delivery permit. A lot of the companies that are saying they're not going to deliver alcohol are not doing it because they haven't gotten the permit. They're doing it because they don't want the liability. And because, if they deliver to a minor or they deliver to somebody who's obviously intoxicated, then the issue comes back on them and there's liability. So right now we're in a state of flux on that, and they really haven't. Some third-party deliverers have embraced it and they're dealing with it. Others are still tentative.
I'd hit up your rep though. Hit up your rep, because if you're not being able to get serviced by a delivery driver that can make that delivery on time, then that's a customer service issue, 100%.
So here's the challenge. The follow-up on that is very simply, they deliver Total Wine or Twins, but they have challenges and want to charge us extra liability protection to deliver ours. So people can call the same delivery company and receive alcohol free-flowing from, say, Twins or Specs or Total Wine. But when they call us, we pay an extra service charge to deliver the same product.
Yeah. And I think that's
Is there any legislation that's going to affect that?
Now, the legislation's not going to affect it because right now it's standard relating to who delivers it. I think what you're seeing is there's a lot of tentativeness in the third-party delivery because some of them are realizing that there's issues out there. None of this has hit the courts yet. All of it came up during pandemic. So we have the statute, which is fairly simple. We've got interim guidance from the TABC. We don't have TABC final rules, and we don't have any court cases to be able to do it. So it's sort of a gray area right now, and it's going to stay gray for a little bit. What you need to realize about the law is two things. One is the law is reactive. It reacts to situations. It's not proactive. So you'll never get a court that issues an opinion about what's going to happen. You just get a court to issue an opinion about what did happen. And also in connection with that, the legal system got slowed down and hit really hard from the pandemic. If you were set for trial in 2020, you're probably not going to trial to 2022. And so a lot of these cases have been delayed a lot. So that's why we're giving you best practices. But if you're asking me if we know the exact answer, there's not been a court that's decided those issues yet. There's not a judicial interpretation.
I want to encourage you guys, though, if you have not considered the possibility of delivering your own product, if every mom and pop pizza joint in America can do their own delivery for the last 50 years, you can do it. If you're confused about how to characterize your employees, call Denney. But if you're confused about how to spin up a delivery program, whether that's one person, 2 people, 36 people, depending on what volume you think you might be able to do, as we're pivoting, as we're coming out of COVID and into recovery, maybe you can take that back. I mean, why do we all have to be beholden to Uber Eats and DoorDash who are war profiteering on us while every mom and pop pizza place had the ability to just, put the plastic triangle on the car and drive around? So I would really encourage you to not just see it as a barrier to entry to, well, why can't we deliver our own stuff? Yeah.
Do we have any other? Yes, okay. Yes, ma'am.
So I have more feedback than question. I'm kind of just here for fun. I don't own a restaurant or anything.
Well,
just here to absorb knowledge. But I'm a mandated reporter in Texas for child abuse, and so I wanted to feed back to the immediate word for sexual harassment. So for child abuse, we have up to 48 hours to report. So I would assume that the word immediate would, kind of correlate to that, give you that 48-hour grace versus 24 hours.
Thank you for that. Thank you for that feedback in your space. I think, when we start seeing court decisions in relation to identifying was it immediate action to remedy the sexual harassment, and I think various circumstances are going to apply, but I think they're going to look to examples like your industry to determine what is immediate and what's realistic as well, right? But at the same time, I think intentionally they implemented immediately to supersede the U.S. Supreme Court definition of prompt remedial action. So it's interesting, something to follow for sure.
It's a really good suggestion.
So at this time, I'd really like to get you to give a round of applause to our Rachel, Gladys, and Karen who did our cocktails tonight. I think they're not. So I also want to encourage all of you who, in 45 minutes or 30 minutes, there's going to be the Lone Star Bash is going to be starting. If those of you who haven't picked up your wristbands or haven't gotten your tickets, you need to. I think it's going to be a great party tonight. And I want to thank you for coming out and paying attention to 3 lawyers talking about boring stuff. So thanks a lot.
Thank you, guys.